Well, good morning, everybody. My name is Tom Hubrick. I am the president of Hubrick Resources. And for those of you who don't know our firm, we are located outside of Reading, Pennsylvania, and we do pretty much everything HR. We have about 500 clients and a staff of 12. And we are just delighted to have my friend Jonathan Siegel here with us today. And so, Jonathan, welcome. Welcome. We're certainly glad to have you.
Really happy to be with you, Tom. Thank you.
Yeah, yeah. So let me just give you all, for those of you who don't know Jonathan, and we have quite a few clients on here that are not HR practitioners, so you may not know Jonathan or much about him. So I'm going to give you a brief bio about Jonathan. Jonathan's a partner at Duane Morris in its employment group. He is also the founder of the Duane Morris Institute, which provides business-focused training to HR professionals, in-house counsel, and other business leaders on a whole host of employment issues. Jonathan's practice focuses on maximizing compliance, minimizing legal risk, and marrying culture with compliance. The core of Jonathan's practice is helping to develop systems to prevent discrimination, harassment, and retaliation, and to respond to alleged or actual discrimination, harassment, and retaliation. Jonathan also works with employers to help minimize the legal exposure with regard to their DEI programs. This work focuses not only on policies and practices, but on other communications and culture. Jonathan also has developed an experience in religious freedom. This includes helping companies maximize religious accommodations and inclusion and minimizing religious discrimination and harassment, such as anti-Semitism. Jonathan has provided training to federal judges and other members of the federal judiciary on various employment issues for more than 25 years. He has testified before the EEOC in Washington and congressional committees on various employment issues, including harassment. In addition to the 500, and I think that's probably a low number, articles he has published on employment law and HR issues over the years, Jonathan has been published in areas in organizations such as the Associated Press, Reuters, the Wall Street Journal, New York Times, Washington Post, the Society of Human Resources Management, Fortune, CNN, and a whole lot of others. And just on the DEI front, alone in 2025, Jonathan has written articles to the Washington Post, USA Today, ABC News, Good Morning America, and SHRM, Bloomberg, The Spectrum, Law 360, and HR Drive, among many others. Jonathan also is a regular presenter at SHRM chapters and the National SHRM Conference, which Jonathan's doing again in Orlando this year. Now, Jonathan, I want to really thank you for being here with us today, not only because you're certainly a very busy guy, but you also had dental surgery yesterday. So just to forewarn all of you, if Jonathan is slurring his speech, this might be dental abuse, but not substance abuse. So please just know that. Okay, well, let's go ahead and jump in. We're here today to talk about the EEOC's priorities, specifically as they relate to DEI and religious discrimination. And the timing could not be more perfect with last week's press release, where Andrea Lucas, the EEOC chair, delivering the Trump administration's priorities and executive orders. And as a reminder, those four key enforcement priorities include DEI-related race and sex discrimination, protecting American workers from national origin discrimination, religious discrimination and accommodation, and defending sex-based rights at work. Today we're going to focus on DEI and religious discrimination in the interest of time. We could certainly, Jonathan can spend hours of time on any one of these four topics, so we have an hour. So we're going to pick these two, and we're picking these two because these are two that we have really seen a lot of our clients asking questions about. So we're going to dig right in, and we're going to talk about those. So also, too, if you have any questions, please post those in the chat box, and we will get to those questions at the end of the session. And as a reminder, if we do run late, we will be sending the recording out. So don't worry, you're going to hear everything. We do have a hard stop, though, around 10:20. So, Jonathan, let's jump right in, right?
Wonderful.
The one thing is, the one thing again for a lot of our clients they're smaller organizations who, I know we have some clients on here that they may not even have an HR department. So, not to. I think it might be very important just to make sure people understand what DEI, the definition of DEI. So I'm gonna rattle off my definition. So diversity, having a mix of different people, backgrounds, identities, and perspectives. In the workplace, equity is ensuring fair access to opportunities and resources by addressing different needs and barriers. And inclusion is creating an environment where everyone feels valued, respected, and really able to participate fully. So, in short, DEI is about building fair, inclusive environments where diversity can thrive. So, Jonathan, let's get rocking here. We've been rambling on enough. So, is all DEI now illegal?
First, I like your definition of DEI. Second of all, the answer to your question, get a one-word answer from a lawyer. That's rare. No, all DEI is not unlawful. Employers can try to include diverse talent, attract, retain, advance. What employers can't do is engage in sex or race-based discrimination to get there. There are kind of two extremes that I sometimes have heard. In the past, I heard some people say if the goal is to increase diversity, it's fine. That's not true. Title VII does not accommodate considering race or sex, even if the goal is to increase diversity. The other edge of it is there's nothing we can do, and there's still plenty that we can do. The executive orders issued by the president in the early first week of his second term said we're trying to stop illegal DEI, not prevent all DEI. Illegal DEI, in effect, means discrimination based on race or sex. Usually that would be against someone white or male in order to achieve greater diversity, someone who's not white and or male. That's unlawful. So you could have an earnest desire to increase the diversity of your workforce, but if the means by which you do it are unlawful, and we'll talk more about that, then you could end up on the wrong side of a claim.
Hmm. Yeah, yeah, for sure. So, one of the things that's been very confusing to employers is, what exactly is illegal DEI? The lines seem to be blurred there for a while.
So let me give you three examples of what's clearly illegal, and then I'll include within each example what, number one, a quota. 30% of our employees will be women, our supervisors. Unlawful per se. What about an aspirational goal? Likely to be seen as a proxy for a quota. At least it may be attacked on that ground. So quotas per se illegal. Aspirational goals, risky. Another area would be set-asides. We want to make sure that we have at least one non-white male in each business unit. I'm making up the terms of this manufacturing organization. So this next hire will not be a white man. It will be a woman and or person of color. That's setting aside a position. That's per se unlawful. What about a Rooney Rule without going into the football, where you have a diverse slate? EEOC and DOJ have attacked the Rooney Rule. There's some language in court opinion suggesting it underline may be okay, subject to certain conditions, but I think that's pretty risky too in today's environment. The third, and these are only going to give three, is considering race or sex as a plus factor. It's not the sole reason, it's just one reason why we're looking at two candidates and we give the nod to the woman or it could be the man to increase diversity. That also would be unlawful. And again, the fact your goal is to increase diversity doesn't provide a defense to liability. In fact, it may be an admission of
Hmm.
liability.
Yeah. Yeah. Thanks. Thank you for that. So, Jonathan, going back in the day when I was in college taking human resources classes, and even as early, I finally sat for my SPHR certification. I guess it was 3 years ago now. Um, we learned all about reverse discrimination. I remember it being on the little card when I was studying. So, is that what we're referring to here?
Interesting. You're correct in the following sense. Historically, we've talked about discrimination against majority groups, against men, folks who are white, folks who are straight, as reverse discrimination. And there's been a split in the courts on whether there are different rules for discrimination against majority groups or minority groups. And those terms feel a little out of date today and may not apply. You could have a hospital and looking at nursing, and the majority group is women, not men. But historically, the term majority group meant men, individuals, male, white, straight, could be Christian, etc.
Mm-hmm.
The Supreme Court last year in the Ames case made clear that the
Yeah.
burden of proof to bring discrimination claims is the same for individuals who are white, male, or straight as it would be for individuals who are black, female, gay. There's no distinction there, no higher burden of proof. To borrow from the Supreme Court, there's only discrimination is discrimination.
Mm-hmm.
To borrow from Chair Lucas, there's no such thing as reverse discrimination. Historically, we didn't see as many of those claims as a result of the Ames decision, as a result of the increased focus on DEI. We are seeing more of those cases. So employers really need to be thoughtful and recognize that when they're looking to make a decision, everyone in your workplace falls in a protected group. I hear people say,
Mm-hmm.
Tom, what does this employee fall within a protected group? If they're male or female, black or white, and I know there are other options on race, obviously,
Mm-hmm.
gay or straight, doesn't matter. Everyone's in a protected group. Had a
Mm-hmm.
wonderful example of this, wonderful, except for the company that had to pay a little money to make it go away, where an HR manager said, "Oh, don't worry about this termination. It's a young white guy. He's not
Mm-hmm.
protected." Well,
Mm-hmm.
young wouldn't be, at least in Pennsylvania, but white guy would be, and that statement was used as an inference of discrimination, and
Mm-hmm.
that case got resolved. So we all have rights, and they're all equal.
Yeah, yeah, very good. I know for many, many years, that was, the white male under 40 was the only unprotected class, right? And so that clearly has changed. So, and an example, what if an employer has, let's say, two candidates, they're both equally qualified, and let's just say one's a white man and the other is a black woman, and they just can't decide which person they're both equal, they love them both. Can the employer break the tie and hire the black woman to increase their diversity under the new regs?
Let me make the fact pattern even more compelling, Tom. There are seven leaders, and six of the leaders are white men, and there's an opening. And this is that seventh opening, and they want to break the tie here. Absolutely, unequivocally unlawful. And I should add, under the prior administration, under the current administration, the law has not changed here.
Hmm.
What's changed is greater enforcement. Can't break a tie. Now, I have to say, I've never had a tie. I've wanted to hire more than one person. We can look at differences in perspective, differences in experience, differences in background, so long as they're not
Hmm.
proxies for race, sex, etc.
Yeah, yeah. No, that's a very good point. So, all right. So what are some things employers can still do in the DEI space?
Well, let me tell you that the EEOC has, in my opinion, put out some very helpful guidance on what is lawful and what's not unlawful in the context of DEI. You can Google EEOC guidance DEI, and you'll find some really helpful material. Part of what matters is our motivation. If the motivation is to increase diversity, we're heading down the wrong road. If
Yeah.
the motivation is to prevent discrimination, not a safe harbor, but we're heading in the right direction.
Hmm.
So steps to ensure that everyone who's accessing the process is subject to certain same or similar questions in interviewing. That's something clearly an employer could do. Removing names and job titles from or addresses from resumes when you review them, so there's no unconscious bias. It's
Hmm.
not to increase diversity; it's to prevent discrimination. That is something that an employer can do. In fact, may benefit from doing.
Hmm.
An employer can have employee resource or affinity groups, a group for women, a group for men, so long as they don't discriminate based on the groups asking. So if you say yes to a women's initiative, it's going to be harder to say no to a men's initiative.
Hmm.
And you have to make sure the groups are open to all. So if you have a Black affinity group, it has to be open to white folks too. There can't be any segregation or separation within the group. And there are other details, but the affinity groups, and I'll post an article I wrote in the chat as I'm thinking now on affinity groups is a good example. Some of the larger employers who are on this call may have them. I've heard some employers say we can't. Some say, of course we can. And again, yes, if open to all, no segregation or separation within them. Segregation is the word of the statute. So employers can do that as well. There can still be mentoring programs, but you can't just say we're going to have a mentoring program for women. First of all, I kind of find
Hmm.
that offensive to suggest all women need mentoring and men don't. Beyond that, you can so beyond that, it would be illegal to the extent it's perceived as, and I think it would be, a benefit of employment. So I think what the more rigorous oversight of DEI kinds of ask us all to do is step back and say, as a business matter, does it make sense only to offer leadership training to part of the workforce? I
Yeah.
think if it's based on high potential, yes. If it's based on race or sex, no. So to me, the business and the legal go hand in hand.
Yeah. And what is that called, Jonathan? The flip test, where, let's say you wanted to do a women, a women leadership
Yeah, yeah,
program to
yeah.
promote leadership within women, that you just flip it and say, okay, well, what if you were to offer something like that specifically to men? That probably doesn't
Yep.
pass the sniff test, right?
The example you gave is this exact example that EEOC Chair Andrew Lucas gave at a talk in Philadelphia 3 weeks ago. And basically, what she said is if you want to know if it's okay, flip it to test it. You have a black woman and a white man. Can you break the tie by picking the white man? No. So the same answer is no in terms of picking the black woman. Um, Differences in perspective, differences in experience, those are things that are all legitimate to consider so long as not proxies. But to flip it to test it is a really good example, a really
Yeah,
good, and what you said is aligned with what the chair of the EOC has said.
yeah, yeah. So what about federal contractors and subcontractors regarding DEI? My understanding, there might be some special issues for them.
Yeah, there are the executive orders that came out. Let me begin by saying, as a federal contractor or subcontractor, you're basically certifying that you're in compliance with federal law. And what the executive orders have done, and I'm in the interest of um, not making people fall asleep. I'm not going to go over all the executive orders by number, but here's the general what we've seen that the Trump administration has said that if you are a federal contractor or subcontractor, you're going to need to certify that you don't discriminate based on sex, race, etc. And even more specifically, on the most recent executive order, a heightened focus on discrimination based on based on race. And if you have made a certification that is false, then you are subject to the False Claims Act. The theory would be you have taken money from the government in violation of an assertion that you don't discriminate. Now, the False Claims Act, it doesn't fit as naturally in this context as in others. The first company that got hit was IBM, $21 million. They had certified, according to the
Wow.
government, that they didn't discriminate. The government found that they did. They went for $21 million and got it. That's only a piece of it. When the government apparatus gets into place on a Small Claims Act, did I say small? I meant to say false. False. I keep saying small. I apologize. False Claims Act claim. Um, it's expensive, it's time consuming, and it's draining. So if you're a federal contractor or subcontractor, and I've had some employers say, well, you know what? We're just not going to take federal money anymore because we don't want that risk. That's a business decision, not a legal decision. But the legal is number one, if you're going to take federal money, you want to make sure that you can say in good faith, and we'll talk more about that in a moment, that you don't discriminate. You don't want to be low hanging fruit for the government.
Yeah.
I also want to mention that with regard to affirmative action, there were two categories of affirmative action historically. One was on behalf of women and certain minorities. The other was veterans and the disabled. Category one doesn't exist anymore. By executive order, President Trump revoked the prior executive order, which had held that you could engage in, and in fact were required to do so, engage in affirmative action to attract and promote women and minorities. He revoked that executive order. It's not required, and in fact, it's highly risky. So if you're still doing affirmative action based on race and sex, you may be walking into a discrimination claim. The other executive order based on disability and veteran status, that still is lawful. An executive order can't reverse a statute, and the statute says that those obligations are by statute, not by executive order. So if you are a federal contractor or subcontractor, talk with your lawyer. I forgot to say this. This isn't legal advice pertaining to specific factual situations. Now that I said my disclaimer, talk to a lawyer if you're still doing affirmative action for women and minorities. And if you're not doing it for disabilities and veterans, and we're talking about only federal contractors and subcontractors, don't want to go in one area, still need to go in the other. Regardless of whether you're a federal contractor or subcontractor, you don't want to discriminate, but the risks are higher for contractors and subcontractors because of this False Claims Act. And it's the kind of issue where when I've had companies in other contexts, for some clients serve like an outside general counsel, and they get these kinds of claims. They get something that they're going to be subject to a False Claims Act. It's pretty shattering. So we should do what we can to avoid it.
Yeah. Jonathan, one last question, and in there's some time, I guess we should probably make this one brief, but when is it time for an employer to conduct a DEI audit?
When is it time? First of all, there was one question. I just want to make sure can mentoring and coaching sessions specific individuals, is that okay for contract revolution? And I haven't forgotten your question, Tom. I just wanted to make sure.
No, please go ahead and feel free to
that I
answer
saw
some of
that.
these.
And the
Yeah.
answer is sure. If it's a specific conflict, then those individuals. But you couldn't say, well, there's conflicts between these four employees, and we're going to have the two white employees receive coaching because they're not understanding, unless they've engaged in bad behavior. that's different. But if it's conflict, then it's based on individuals having conflict, coaching there is fine. So for companies that have a history of racial exclusion in hiring and currently have 80% white board leaderships, what, if any, steps can they take to diversify? On the board, you can have on boards, the law doesn't prohibit per se the consider of race or sex because, at least under federal law, board membership is not actual employment status. So the restrictions on employment under Title VII don't apply to board membership. Footnote, argument under some state laws it may, and that may vary whether it's for profit, nonprofit, how they're perceived. But at least under federal law, it wouldn't be impermissible. But the government, in a number of cases, has taken the position that if there's discrimination, what they would say across the pond, positive discrimination to increase diversity, no such thing as that here. At the board level, that may set the tone and that may make it more likely there'll be an investigation. What I think employers can do, among other things, is cast a wide net. A wide net. Motivation matters, not to increase diversity. A wide net to make sure that the employer doesn't exclude talent. Why would I go to an HBC? Because I want the talent there, not because I want to increase racial diversity. Footnote, obviously there are white folks there too. If you say your goal is to increase diversity, you're really going to end up on the wrong side of it potentially because motivation matters. The reason why diversity matters, in my view, the paramount driving factor is talent. Focus on the talent, not the diversity. That's just a short answer to a very thoughtful question that someone asked. And then in regard to set asides, I haven't seen people explicitly say this role is for a specific type of persons, but it's clear that they've reserved it. Um, uh, Many DI executive positions are filled only by Black women or at most a Black person or a woman, and this fact is widely known, but nothing is formally stated. There can be, I'm not saying there always is, but if there are two candidates and the white man is more qualified than the Black woman, and she gets it because of the assumption she'll do better at diversity because of her color and or gender, that is a discrimination claim. Can't ever talk about cases, so I'll just deal with this in the abstract. Got a letter, hypothetically, at one point in my career, where a white man alleged he was denied a position for which he was qualified because he was white, and the person who got it was someone of color. And based on the objective qualifications, he was more qualified. So here is the irony, and I don't think most DEI programs discriminate, but I do think some do. To the extent that DEI leadership positions are set aside explicitly or implicitly based on sex, gender, race, that would be an area for challenge. And then you asked me a question, which I didn't answer because I was trying to answer the questions on the screen. So your question was, when's a good time to audit? Well, first of all, please don't send emails to your colleagues saying now, oh, we have problems. I guess I would say, oh, you might not be really thoughtful about what you put in email. Reach out to your counsel or get counsel. If you have a DEI program, if you are doing anything like aspirational goals, set aside, diverse slates, considering race or sex as a plus, inclusion or development programs like mentoring, resource groups that are limited based on race or sex or segregated based on race or sex. If you have pipelines of employees that are based on sex or race, internships, fellowships only for Black, internships only for women. If you have DEI goals incorporated into compensation, promotion, succession planning. If you have programs that are neutral on their face, but the goal is to increase diversity, then I think you want to be auditing. Audit initially under privilege, so your good intent doesn't become discoverable. That can be a benefit to you as well.
Yeah. Yeah. Thanks. Oh, that's great, Jonathan. Thank you so much. Kind of lead us into our second subject for the day, as it relates to religious freedoms and religious rights. And again, this has been another one that has been a hot topic with our clients, especially kind of in the region where we do a lot of our work. So, and so I guess my first question would be, what do religious freedom and religious rights mean in the workplace?
Religious freedom, if you will, is the broad term that would potentially cover. I did for SHRM 2 years ago a 4-hour program on religious freedom. And someone said to me, "How did you spend 4 hours on that?" I said, "No, I really needed 8."
Mm-hmm.
Um, no discrimination, no harassment, helping ensure religious accommodations, helping to protect religious expression and observance, and no retaliation. Those could be seen as the 5 pillars, if you will, and I'm putting expression in there that's different from other other areas. What's fascinating about this area of law is that you have, as employers, as employees, it's not only what you can't do, you can't discriminate. It's affirmative rights based on religion. It's affirmative rights of individuals to express their religious identity. That's not true in other areas to the same degree.
Yeah, yeah. I think where I get confused sometimes is, what I mean, in terms of religion, what does that even mean, right? So, I mean, in the terms of the workplace, what constitutes a religion? And it sounds like a simple question, but I guess it may not be a simple answer.
Oh, many a lawyer drives a BMW because employers have questioned whether someone had a religion. In order for an employee to bring a religious discrimination claim or an accommodation claim, all they need to have is a sincerely held religious belief. So let me unpack sincerely held versus religious belief. A belief in God is not necessary. It doesn't even need to be monotheistic, non-theistic beliefs also could be religious if it, quote, occupies in the life of the individual a place parallel to that filled by God in traditionally religious um, persons. An employee may have a religious belief within the meaning of the law, even if no religious organization espouses it. An employee may have a religious belief within the meaning of the law, even if the religious group to which the employee professes to belong doesn't share that belief. There were individuals during COVID who said, based on my faith, I'm a Christian, and based on my understanding and belief, I can't get a vaccine. Well, the
Hmm.
Catholic Church didn't prohibit it, but that individual, the vaccine was against their sincerely held belief. That could be protected. So I begin with an assumption that we should define religious belief broadly. Things that are clearly political, secular, etc., are different. But some overlap doesn't mean the protection is lost. So it's an area where we could literally spend 3 hours on what's a religious belief. What people need to know is the courts have recognized, at least one court, that veganism could be a religious belief. Um, Another court talked about the church of body modifications and where individuals needed to scarify, etc. And people would say, well, that can't be a real religion. Of course it is. Does it hold a place in the person's life comparable to?
Hmm.
General rule, subject to exceptions. The courts kind of look to see whether it's comprehensive in nature. So if it's one belief, it may not be enough. It needs to be a comprehensive belief structure. So all the organized religions, Christianity, Islam, Hinduism, Taoism, Judaism, etc., less known religions, um, potentially Wicca, uh, as I said, Church of Body Modification, or I am not of any particular religious group, but my ethical structure tells me that that the following is right and wrong, and that right and wrong are sort of about imponderable matters things like involving life and death, etc., that may cover too. So I kind of begin with the assumption if someone's raising it in good faith, probably protected.
Hmm. Hmm.
Probably, but very fact specific.
Yeah. Yeah. So, I mean, who's covered under religious protections? I mean, I think maybe you kind of already answered that, but I mean, does that? I mean, maybe you just want to expound on that a little bit.
Yeah, it would be anyone who has, well, it could be religious belief, practice, or observance. So if I practice Judaism, that could be enough, even if I don't have a belief structure in God. If I have a belief structure in a higher power that's comparable to that in religious groups, then I have these are all mights because these are really fact specific,
Hmm.
have a religious belief and be protected under the law, even if I don't follow certain observances. It's really important, and I'm just going to, for the moment, look at the statute. The definition under federal law of religion is religious belief, practice, or observance. And the state law, effectively, the Human Relations Act, mirrors the federal law. So if an individual has a religious belief, practice, or observance, they are probably protected against religious
Hmm.
discrimination.
Yeah. Yeah. So we spoke the other day, and you had some pretty good examples. Can you share some examples with the group of what religious discrimination is? And just real quick before I have you answer that question, we are surprisingly running on time, Jonathan. So if folks have other questions, please don't be afraid to throw them in the chat, and we'll get to those.
Yeah.
So,
We're going
so
to get to
again,
undue hardship in a moment, but so let's talk about discrimination.
yeah.
It could be hostility toward. I don't want to hire someone because they are Christian. And the current administration had a commission on the eradication of bias against Christians. I've seen it, I've heard it under Ames, equally unacceptable as bias against any other religious group, even though in the US there are more Christians than
Hmm.
any other group, still equally unokay. Or it could be affinity bias. You know, I'm Hindu and I love to work with someone who's Hindu. I have no animus against others who are not, but I favor someone who's like me. That could be a form of
Hmm.
discrimination. It could also be based on stereotypes. Tom, I did a program when I was at SHRM. I mentioned this, and I had five groups: evangelical Christians, Hindus, Jews, Muslims, and atheists. And then I had five stereotypes, and I asked people to correlate them. They were 5 for 5, almost everyone. So we all kind of know some of the stereotypes about various groups. I'm not going to repeat them because they're too ugly. But if I said to you, you know what, I'm not even going to go there. We can't stereotype based on this. We can't say that someone who's a conservative Christian wouldn't be open to certain ideas. We can't say that someone who is Muslim is less likely to be X, Y, or Z. Again, I'm not even going to go through the examples, but the stereotyping can exist here, and that's highly, highly problematic. It could be based on appearance. That's also unlawful. Well, this
Hmm.
individual is Jewish and he wears a kippah or a yarmulke on his head. Or she's an Orthodox woman and she dresses in a more reserved, quiet manner. You can't discriminate for someone because of their faith, against someone because of their faith, um, because of stereotypes, appearance, including client preference. You know what? This employee is Muslim and she wears a hijab, and I'm not sure that people are going to be comfortable with that. Well,
Hmm.
that's not a reason to discriminate. You
Hmm.
can't discriminate because of
Hmm.
customer preference.
Yeah.
And I guess the last biggie would be you can't discriminate because you don't want to accommodate someone and you think you potentially would have an obligation to do so.
Hmm.
And there's a Supreme Court case on that. So
Yeah.
those are some examples um, of when of examples of discrimination. Now, there's some real quick questions. What happens when these things come into conflict? I once worked somewhere where an evangelical Christian said it was part of their religion to proselytize, and they kept bothering people. Is it legal to prevent the person from proselytizing? The There's some guidance for the federal sector that's probably going to apply to the private sector. What I would say is an individual's right to proselytize ends when someone says it makes me uncomfortable. At that point, it could become harassing. The key is to treat it, not to say that proselytizing in and of itself is wrong, because that may be protected to some degree under the law. But when I say it makes me uncomfortable, then someone's continuing to do it is a problem. So not per se a problem to proselytize. In fact, it may be protected by the law to some degree. Once someone says they're uncomfortable, that's a problem. If you're a supervisor or an owner, you got to think about whether your proselytizing may send a message. Unless you're in my faith, whatever that faith may be, um, I think something's missing in you. And when you proselytize Jane Doe and then she doesn't get the promotion, is she going to argue that the reason she didn't get the promotion is because she rejected your proselytizing? That's actually a quid pro quo claim in the context of religion. You didn't accept my faith, you rejected that overture. People think of quid pro quo only as sex, it also can be in terms of religion. What are the biggest mistakes employer makes? We'll come to religious accommodations in a second. But I just wanted to hit the discrimination issue.
Yeah. Jonathan, did you answer the question I guess Julio mentioned? I'd love to hear a little more about sincerely held beliefs versus undue hardship under business.
Okay. So an employer has a duty to make a reasonable accommodation if they become aware of a religious belief or practice which conflicts with an employer requirements. Have to have an obligation to consider, engage in a good faith interactive dialogue.
Hmm.
So the law used to be that undue hardship existed if the proposed accommodation imposed more than an undue de minimis burden on the employer. And as a result of that, there were very few cases where it was such an easy standard to meet. The Supreme Court, more than de minimis, easy to meet. So undue hardship was easy to meet. In the Groff versus DeJoy, a 2023 decision, really, interesting decision. The Supreme Court said the standard is not more than de minimis. The standard is, does it impose a substantial burden? Now, the ADA says significant burden for undue hardship. Title VII says substantial burden for undue hardship. I don't know what the difference is between significant and substantial. I don't know if that difference is significant or substantial. As a legal matter, the Supreme Court said they're not the same. As a practical matter, I would look at the ADA guidance, and if it wouldn't be okay under disability, it's probably not going to be okay under religion. I think that's the practical approach. So, what would be an example of an undue hardship? So let me give you a couple of things that are potential accommodations that employers might need to consider. Prayer break for someone who's Muslim.
Hmm.
Now, if they need a prayer break and you'd have to shut down a line of business, undue hardship on the employer, that might be an undue hardship. So whether it's okay might depend on the position. No work on Saturdays for someone who's Jewish and celebrates the Sabbath Friday night and Saturday. For some positions where Saturday work is intermittent or others can cover, that may not be an undue hardship on the business. If there are only two people who can do it and the other employee isn't willing to trade, that would be an undue hardship to mandate. Here's a key issue in undue hardship. You have to focus on the impact on the business, not on the impact of coworkers. Because the second issue in Groff, which didn't get as much attention, was undue hardship on whom? It's not on the employees, it's on the business. It would be undue hardship on the business to require one employee to work every weekend because they could lose that one employee. It would be undue hardship on the business to hire someone to work every other weekend um, because of training, because of it, access to information, etc. This is a real fact-intensive area. Let me tell you the biggest mistake I see in undue hardship, the comparators. We need to make individualized assessments, but what have we done in other cases? An employee said, I want to come to work late so I can go to mass every morning before I come to work. And the employer said, can't do that. That's an undue hardship on the business. We want to start at 9. But they made that same accommodation to a young father taking his kids
Right.
to childcare.
Mm-hmm.
Well, that would seem to be discrimination in comparison. And it's not all or nothing. No, we can't say you can come in 5 days a week late. We have meetings every Thursday at 8 o'clock. You have to be here on Thursday. Don't go all or nothing if you're an employer. Someone asks for something and it's more than you can do, offer up what you can do so you can show your good faith. Ideally, you make the accommodation. If not, you have that track record of at least having tried.
Yeah. A lot of that feels like the interactive process under the ADA.
Yep.
So,
Under Title VII, the courts are split on whether the interactive process is the same as under the ADA. There are some courts that call it bilateral cooperation. I
mhm,
want to put away all those legal niceties. I would treat it the exact same way, exactly as you said, Tom.
mhm, yeah,
Interactive like you would under the
yeah,
ADA. Do the
yeah,
same under the Title VII.
yeah. We have a couple other questions, but let's keep going, and
Okay.
we'll get to those questions at the end, just to for those that might have to jump off.
Okay.
But we will answer those, and again, we'll be sending the video out. So, what about harassment? What are some examples of religious harassment? We talked about discrimination, but what about harassment? What are you seeing there?
Well, harassment could be making fun. The law provides, at least in Pennsylvania under federal law, it needs to be severe or pervasive. So I'm going to give examples which alone in and of themselves may not be harassment, but they would be harassing and they could, if there's enough of them, lead to a hostile work environment. So let me give you a couple of examples. Hate words to describe a religious group, such as the K word for someone Jewish.
Mm,
Um, Comments that are making fun of someone's attire. Someone wears a turban and making fun of that employee because of that, even that's associated with their religion. A case that was reported by the EOC, and it was in a footnote, and I read it, where an employee was Muslim, as a result of which that employee did not eat pork. And when the employee came into work, there was uh, a picture of a pig's head on his desk.
mhm,
Again, I'm reluctant to even say it. That to me would clearly um, nicknames, someone who is very religious, devout Christian, and you know, being called a Bible belter, and other things which I wouldn't even feel comfortable saying,
mhm,
making fun, making jokes about, stereotyping or joking about someone, talking about an atheist. By the way, I forgot to say something really important. People who have no religious beliefs are also protected. We can't discriminate against them either. So if someone doesn't have faith and people start talking about someone, this godless employee, blah, 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 bad mouthing the person, that could be religious harassment. Let me give you sort of one of the hot button issues today. The EOC has made clear that they're going to focus on anti-Semitism. I'll mention I have the honor of having Chair Lucas on a webinar we're doing, no cost, on June 3rd on our website.
mm,
We're talking about anti-Semitism. You can see anti-Semitism, unless you're living under a rock, which might be a nice place sometimes to go.
mhm,
Anti-Semitism is higher than it's been in most of our lifetime, really the highest recorded level of
mhm,
anti-Semitism since the Holocaust. And it tends to be falling in three categories: anti hostility, at least in a workplace, based on the religion; hostility based on the peoplehood, nothing to do with the fact it's not making fun of or derogating the religion, but stereotyping about, like the person that once said to me, I'm looking for a Jewish lawyer. Do you know what I mean? And I said, I know what you mean. I'm Jewish and I'm a lawyer, but I won't be your lawyer. And then the third is discriminating or harassing someone because of a perceived connection with Israel. Criticism of Israel is not in and of itself anti-Semitism, but
Mhm.
harassing someone in your workplace or discriminating against them because of what you perceive to be wrongs by or just mere association with Israel, um, that could and likely would be discrimination, harassment. So an example would be an employee who came to work, let's talk about, and was regularly peppered with questions. What do you think about what Israel did now? And all these questions, and the employee's like, why are you asking me these questions? I'm not, I'm not the representative of the government. But or the employee who had on his desk pictures that could inflame, etc. I'm trying not to be too explicit. So
Mhm.
those are just some of the examples.
Yeah.
I'm trying to think if
Yeah.
there's anything major I missed, other than to say it can be not only in the workplace, but also affecting the workplace. So if someone is posting on a social media site and it is or likely to be seen by employees, particularly if it's an employer, and there are religious stereotypes, I'm just going to give one other example. Someone talking about Jewish control of the media, the government, finance, and that person is a supervisor. What's happening out there may affect the workplace. That could be harassing too.
Mhm. Yeah. No, that's great. Those are some really helpful examples, and
Thank you.
I learn best by example. So thanks for that. So I would only assume then that the law is the same regarding religion it is for sex and race. You can't retaliate against somebody if they complain about it or request accommodation.
Yep, you're spot on, and really important to remind people can't retaliate against someone because they complain about religious discrimination, they complain about religious harassment. And thank you for adding reasonable accommodation. There are some summaries out there that don't specifically include reasonable accommodation, but requesting a reasonable accommodation, if you don't, is a for the requirement that you not discriminate includes the requirement that you make reasonable accommodations, and you can't retaliate against someone because they requested an accommodation because that's part of the definition of discrimination. The only reason I'm saying that is I've seen some summaries out there that don't hit the point you said. Spell it out in your policies, spell it out in your training. And one of the questions asked is what was the biggest mistake employers make in responding to reasonable accommodation requests or responding to harassment? I think the biggest mistake is letting line supervisors and managers deal with those issues alone. So an
Mm.
employee says, I need an accommodation based on my membership in the Church of Equitable Distribution, and this is what would be required. And the manager says, there's no such church. You got to be kidding me.
Mhm.
Hostility off the block, right out of the mouth. I can't control what people think. And sometimes I hear things, I'm like, really? But what you say is, thank you for letting me know. I'll check with HR. And then if they don't have HR, they'll
Mhm.
check with you.
Mhm.
Um, but the answer is not to say yes or no in the moment. Don't say no
Right.
because the answer may not be no. And don't say yes because you may be agreeing to something which you really can't. Managers, thank you for letting me know. We'll check with HR
Mhm.
or I'll check with management, senior management, and I'll get back to you.
Yeah.
That's the biggest mistake that I see. The second biggest mistake I see is not going through the interactive process, which you highlighted, Tom, the same or substantially similar to what we do in disability, having a dialogue, which is not just a piece of paper, but actually a conversation
Mhm.
with the employee. And then the third thing, the biggest mistake I see in the context of reasonable accommodations is, well, it's going to be inconvenient for me. Well, inconvenient is not going to be an undue hardship.
Mhm.
And the third, in the context of harassment, I think one of the biggest mistakes that I see is people don't respond to religious harassment, in my view, quite as strongly as they do to racial and sexual harassment.
Hmm.
That doesn't mean we should be more lenient with racial and sexual. It means we should be treating religious on par.
Yeah. Yeah, and just a general comment I'll make here too is it is so important for companies to train their frontline supervisors on employment laws and regulations, and also I just had a conversation with a client the other day where you know, somebody did something and misbehaved, and they just, the supervisor just fired the person without, and obviously the answer should have been no, you don't have the authority to fire somebody. You need to say, even if it was an egregious act, is leave, and we'll get back to you. But your supervisors are agents of your company,
Mhm.
so it's very, very important that you do have leadership training on a variety of things, but most certainly when it comes to employment laws, because we see so many of our clients that get themselves in trouble because of an act of one of their maybe a newly appointed
Yeah.
supervisor that's just never even been trained.
And Tom, my observation is that employers sometimes, number one, when they list their protected groups, forget religion in their non-discrimination policy.
Mm,
What's the message there? Number two, when they do harassment training, you don't have to give 30 examples, but you should have a couple on religion and pick a couple of different religions. When you train your managers on discrimination and harassment, you
hmm.
need to include not only sex and race, ethnicity, but also, among others, religion. That is conspicuously absent from many training programs. That absence may lead, number one, to conduct which could be avoided. And number two, if that conduct is engaged in, the failure to train on it may increase the damages.
Hmm.
Someone asked if an employee wears a crucifix and someone feels uncomfortable,
Yeah, that's a big one.
do they have to take it off? The answer is no. People have a right to wear a crucifix. Now, if someone's wearing, I'm going to do this for myself, so I'm not, I wear a chai, which is the Hebrew letter for life. It's little, it's in my shirt. If I were wearing a 3 foot Jewish star, I think you'd say it's too big. If someone's wearing a 3 foot
Hmm.
cross, it's too big. I'm just trying to give the same analogies.
Hmm.
Um, I think what you need to be thoughtful about, it's not risk free to say it's too big, but it's not risk free to ignore it either.
Hmm.
And we welcome your religious expression in the workplace. We're just focusing on the size of what you're wearing. Would you consider wearing something smaller? Usually those can be dealt with, not all or
Hmm.
nothing. But I need to
Hmm.
say that if someone were to say, look, I want to wear a t-shirt and I want a cross on it, the same way other people can wear t-shirts with Bruce Springsteen on it, unless you can show it's going to result in some disruption or it has resulted in some disruption.
Hmm.
There's that is the area. Discrimination, I'm really comfortable with what the answers usually are. Harassment, usually reasonable accommodation, a little more complicated, but this line on when religious expression goes too far in terms of the law, when the protection is lost, less clarity under the case law, more dialogue rather than directive, is my
Hmm.
opinion.
Yeah. Yeah, we've dealt with a couple situations where folks are very strong in their Christian beliefs, and they've had very, very large, crosses with Jesus, kind of dying on the cross, and it did offend some people. So,
Yep.
but yeah, so and I'm assuming it's the same law regarding the law is the same regarding retaliation for religion as
Yep.
it is for sex and race, right?
Yep. Yep. The law is the same. And look, if someone said, I'm offended by a small Quran, well, we have to treat that the same as a small Bible.
Hmm.
And one of the things that makes me uncomfortable is how often people use the word offended. I wish we could tone down a little bit in our thinking and our share, have a little bit of grace. If something makes you uncomfortable, rather than saying I'm offended, which suggests you did something offensive, why don't we say I'm uncomfortable? Could we work on something where you can be who you are, but I can be a little more comfortable where I am? And, this relates to another piece of training, which is we talk about supervisors, what they do, what they have to do, what they can't do, reporting obligations. But sometimes it's helpful to say to employees, we're not telling you how to raise concerns. We're making
Hmm.
clear you can always talk to the person. You can always make a complaint using the complaint procedure, etc.
Hmm.
But if you decide you want to talk to the person, maybe it's better to say or think about saying, this makes me uncomfortable rather than this is offensive, because I think you're
Yeah.
more likely to get a better result.
Yeah. No. Well, listen, Jonathan, this has been great. Just one final question, and then we might have a couple of questions we'll circle back to
Sure.
in the chat. So, I was thinking about this the other day with the EOC
Goodbye.
with the EEOC, you're like really focusing on these priorities. Um, do you feel as though they're still going to be doing business as usual with all the other charges that they historically have been doing? And sexual harassment's one that kind of jumps out at me. Or maybe not so much again because they're really laser focusing on these initiatives. What's your thought on that?
Um, I think people, I want to be apolitical. I think people sometimes are looking at the EOC on any side of the issue politically and may not be digging deep enough. Number one, the priorities of the current administration differ from the priorities of the prior administration. Undeniable. Priorities change from administration to administration. People can agree, disagree. There'll be a Democrat, they'll change again. Things change in terms of priorities. What has not changed is what I'm going to call the bread and butter issues of the EOC. The EOC continues to bring harassment claims and has recovered for sexual harassment and racial harassment. The EEOC continues to focus on disability claims, failure to engage in the interactive process,
Hmm.
concluding undue hardship way too early under disability. The EEOC continues to look to push the law on pay equity under the Equal Pay Act.
Hmm.
Um, a case in the Third Circuit where the EOC is arguing that it doesn't have to be a pattern. Just one employee of the opposite sex making more could be the predicate for an EEO claim.
Hmm.
The EOC continues to focus on pregnancy discrimination.
Yeah.
So, one of the nice things about any government agency, regardless of where they are going, is to tell people their priorities. Um, I appreciated that when the Biden EOC did it. I appreciate it when the Trump EOC did it. I appreciate transparency. But just because an agency lists something as priorities, that doesn't mean they're ignoring other issues.
Hmm.
So all those bread and butter issues, the EOC is continuing to focus on them.
Hmm.
And the Pennsylvania Human Relations Commission, the New Jersey Human Relations Commission, regardless of where you are, continue to focus on them.
Hmm.
These are issues, the way I would describe it is the EOC's priorities are among those areas where the EEOC would say, and I'm not speaking for the EEOC, historically there was under enforcement. So now they're elevating the issues to increase the enforcement,
Hmm.
in addition to not in lieu of the bread and butter issues.
Yeah. Yeah. Great, Jonathan. Yeah, and if you want me to read the questions to you, I can, or you can just scroll through them and
I'll
and
scroll. Hi,
and feel
Maria
free.
D. Um, so so if an organization's DI program includes identity-based employee resource groups, what criteria and safeguards should there be? Could someone example, say, a Christian conservative group? Um, if you were first, this is Very interesting topic, Adrian, and thank you for raising it. There are two lines of thought here. I don't know where the courts are going to end up. One is, as long as you say no to all religions, it's not unlawful. So if you say yes to Hindu but no to Christian, that's a problem, or would likely be a problem. There's one line of cases that would suggest if you have an ear, if you say no to all religions, it's fine. There are individuals that argue religions like Judaism, Jewish people, Muslim people, it's an ethno-religion. So it could be covered not only by Title VII under religion, but also under national origin or even genetic information. So if you allow groups for one ethnicity, you would have to allow for another ethnicity, even if it's an ethno-religion.
Hmm.
I think what you want to do, that's the legal factor, is you want to think a little bit about um, what is the business purpose and what is the business need, the business purpose, and how will this advance business goals? And come up with some criteria. I've just given you a couple of ideas, operative word being business. How will this help advance the business? What gap is this filling? Um, I've seen individuals, I've seen the following. I want to have an ERG for blind group. Well, why is this important? Because we want to be able to talk alone as a safe space. Well, you're not going to be able to talk alone because this group's going to have to be open to everyone. You want to talk alone? That's not an ERG. That's called lunch. So that wouldn't meet the business purpose. If someone said, we are um, I'm trying to think we're a Hindu group. We have only 4 or 5 Hindu employees in our workplace of more than 500, and it would be helpful for us to be able to participate more in workplace events and raise areas of pride, of heritage, of experience, etc. That might be different. That might help. So, non-religious based criteria. Arguably, you could have an exception for religion altogether. But I think once you open the door to religion, I think it's hard to say yes to one group and no to another. And by the way, is there a nexus between DEI and religion since we talked about both today? Yes. This month is a dual heritage month. We celebrate and acknowledge the accomplishments, achievements, and contributions of Asian Americans. It's also Jewish American Heritage Month. Be thoughtful about the messages if you do one and not the other when
Hmm.
both are being celebrated this month. So one question is, what if someone asks for Sundays off and you can do it? Now someone asks for Sundays off, and it's 2 employees, so you can't give them both Sundays off. Do you say no to number two, or do you split the difference and say you each can have every Sunday off? I love this question, Kathy, because I had a summer associate research this issue for me last year. Not a lot of case law on it. I think the fair approach is to let them split it and not have the first to arrive get the benefit. But I don't think the law that I think that's probably the better legal answer. With one more time, this isn't legal advice pertaining to specific factual situations. I should note with religion, like disability, collective bargaining agreements are
Hmm.
relevant in making reasonable accommodations to decisions. Maybe not determinative, but maybe relevant. It would be undue hardship on the company to violate the
Hmm.
collective bargaining agreement. So that's another factor to consider.
Hmm. So, would you also agree it's very important when, and we've dealt with this so many times over the years, where, folks say, I can't work Sunday because of my religion, I can't work Saturday because of my religion, is you just can't automatically say no. You need to kind of go through that interactive process with them to see if there's any way you can accommodate that, or not. But you just can't automatically just say no, sorry. We work on Saturdays here.
No, can't automatically say no. Is there any reasonable way you can say yes? If you can't say yes to every Saturday or every Sunday, can you say yes to some? Have you looked at the option of trading shifts? So let's assume you say, is anyone willing to work more an additional Sunday? Yes. And then the question would be, if you can get that,
Hmm.
it may be a little additional overtime for you, potentially based on that person's schedule. That additional cost likely would be not substantial. So that additional
Hmm.
cost, it might have been more than de minimis before. It's not going to be
Yeah.
substantial now. So that's good.
Hmm.
So you're absolutely right. That's the kind of process you need to
Yeah.
follow.
Yeah. And then we deal too on the morale side of this where, okay, so giving somebody their Saturday off or their Sunday off could mean that the coworkers might not get as many Saturdays or Sundays off. And that's certainly something employers need to factor in from a retention standpoint um, for their companies, right? So I'm not sure that would be an undue hardship argument, but certainly that is a challenge that many of our clients have faced.
It wouldn't be an undue hardship argument because employees were jealous of, envious of, resentful of. It could be if it created an undue there's some wonderful, I get too excited when I talk about the Groff case, it's one of my favorite cases, but there's really some very strong language in that case about you can't rely on the employee resentment, etc. But if there's an undue hardship on the company where the company isn't able to operationally work or cover shifts, etc., that you can rely on. And usually my experience has been where there is this the antagonism is where people are being required to cover more
Hmm.
shifts, and then the employee relations impact, not of the accommodation, but making someone work additional hours they don't want to work. That might be an undue hardship,
Hmm.
not framing it as on the employee, on the employer, to the extent the employer has to mandate someone else cover
Hmm.
additional shifts.
Yeah.
A little bit
Yeah.
nuancing there. I know I have clients that work with you, so I want to thank you for what you folks do in the field, but I also want to thank you for inviting me to be on this webinar with you and to talk through two of the four priorities of the EOC, about 35 minutes on each of them, knowing they still deal with the bread and butter issues. I
Yeah.
appreciate the conversation and I appreciate what you do and the opportunity to spend time with you.
Jonathan, it's been a pleasure. We were thinking the other day we've known each other for probably close to 30 years now, and have worked together, several times. For any of you on the call that might be clients of ours who need a really good attorney, labor attorney, Jonathan is one of the best. So, giving Jonathan a big shout out and a plug, and we're truly honored for you to join this call with us here today. So, I hope you all have a great rest of your day, and you know, until we see you again, take care.
Thank you.
Bye.
Thank you. Have a great day, everybody.
Bye.
Peace.